a better mousetrap, and the world will beat a path to your door. That is, until the Supreme Court steps in. The High Court ruled against Aereo today, finding the upstart streaming television service in violation of copyright law. It's a decision that will reverberate for years to come, and critics say will cast a pall over future innovation.
Live broadcast TV, off the air, wherever you are, whenever you want.
That was the promise of Aereo, a service that uses small antennas to capture over-the-air programming and streams it to customers online. Aereo says it just rents antennas, but network executives called it theft.
They're taking our content, they're selling it, they're charging people for it, they're making money on it, and we're not.
Today, the Supreme Court agreed, ruling that Aereo violates copyright law. Writing for the majority, Justice Stephen Breyer noted that Congress specifically amended the copyright law in 1976 to prevent cable companies from retransmitting broadcast content without permission. Aereo, he concluded, does essentially that. But in his dissent, Justice Antonin Scalia warned the ruling will sow confusion for years to come. That resonated in Cambridge, where Aereo's technology was developed.
Aereo is just another example of big interests, fighting off kind of some cool, innovative stuff. And here in Kendall Square, we're all about cool, innovative stuff.
Definitely a bit threatening, I would think. But hopefully we can continue to work within these boundaries, and maybe they might even reverse their decision after we see the effects of this.
As for Aereo, the ruling effectively pulls the plug. All right, well, this ruling coincides with our focus series on how innovation disrupts old business models like Uber. But will today's outcome slow progress? Here to discuss the Aereo decision and its effects are Adam Holland from Harvard University's Berkman Center for Internet and Society and David Harris, tech editor at Boston Business Journal. Welcome to you both.
Thank you.
Thank you.
So it's essentially a copyright issue. And I see you were actually reading the ruling. I haven't.
Everyone I know is reading this ruling as fast as they can, yes.
I mean, is the whole thing about copyright, or does it muddy the issue of innovation with copyright?
I think the answer to both of your questions is yes. It is all about copyright, but it is impossible, even for the court, which is trying very hard to do so, to extricate the copyright ruling from the effects on innovation.
So, David, could Aereo propose a different business model? I mean, cable got around this by actually paying broadcasters fees to carry their content. Would that just be crazy for Aereo? They couldn't do that?
I mean, they could do that. That is one of the options that they could take on, but that really remains to be seen. They could change their business model entirely, but from the people that I talked to today, if they did actually start paying for the content, they probably couldn't charge the low rates that they're charging.
The rates are ridiculously low. I mean, compared to cable, they could double or triple them and still be lower than cable.
Right, exactly. $8 a month is a bargain.
You know, Adam, there's a perception anyway that the Supreme Court, because of their age and other things, that they're completely out of touch with new technologies. I mean, is that a fair assessment? I mean, they had more than a year to really study the detail of that, but I mean, does it was 6-3, so it wasn't exactly unanimous, but is that a fair assessment?
I think you're correct. I think that that's unquestionably the perception of the court. They are getting on in years, and technology is changing far, far more rapidly than the law. On the other hand, this is the court that just today also said you need a warrant to search a cell phone.
Yeah, true.
I think that this ruling does represent an inability to grapple with the speed of technological change and with the implications of cloud computing. It's all of its analogies are based on 1976 era cable TV.
We should also say that WGBA filed an amicus brief on this because we were sympathetic to the broadcasters, and you can understand that, right, David? Because I mean, here's this outfit, you know. So what was the antenna was like $8 a month. You plug it in somewhere, and basically it's collecting all this data for you that the broadcasters are producing, feeding it into your computer, and you're watching it whenever you want. I mean, I remember when there was a lawsuit filed over beta recorders, for heaven's sakes. The broadcaster didn't even want you doing that, so you could play it back later. I mean, you know, so what I'm getting at is that it just seems like somebody's going to find a way around this. I mean, the beta is ancient history. Somebody else is going to find a way to get this kind of data, this kind of programming into our hands without buying a TV.
Sure, and I think that's what that's the good thing about a startup like Aereo is it challenges certain established entities like broadcasters, but you know, broadcasters also need to make money somehow, and
it's their material,
right? And they want some revenue coming in, and of course it is their material. So and I think in this ruling you have a Supreme Court that is sympathetic more to the people who are trying to build a business around that content instead of the technological innovation.
I will take issue that they're not trying to build a business around the content. They have long since built a business around the content, and the Supreme Court is sympathetic to the established big business interests rather than the innovative, perhaps disruptive startup.
So does either of you think that they have any recourse on this at all? I mean, and how quickly will they go out of business? The person talking in my ear has Aereo. She wants to know.
Well, I mean, they might have a few months to survive. It's interesting that the CEO of Aereo released a statement today that kind of didn't address the immediate future of the company, but I'm sure there's a lot of people who are probably they know what's coming down, because Chet Kanoja, the CEO of the company, has previously said that there's no plan B really.
That's correct.
For this.
But if they lose, they're done.
Yeah,
exactly.
we had a little bit of this statement. It reads in part, we are disappointed in the outcome, but our work is not done. We will continue to fight for our consumers and fight to create innovative technologies that have a meaningful and positive impact on our world. It's not really clear what they mean by that, is it?
Yeah, it's glib.
Yeah, it's glib.
Putting the best face on things.
Yeah,
with respect to, is there any way out of this? I don't see an immediately obvious one. I mean, the fact that willing to go on record saying there is no plan B suggests there is no plan B. But I've already heard some speculation based on trying to carefully parse this decision about, well, what if they did this? What if they did that? To me, so far, that sounded like deck chairs on the Titanic. But if you want to play the long game, it may be that now the broadcasters are in the catbird seat with respect to saying, okay, Aereo, we want to do this. We will buy your technology from you.
Yeah, exactly.
You're already doing it. Yeah. We're just going to take control.
Good
so
point.
that might
they can
happen.
make some serious money. All right, Adam Holland, David Harris, thanks
Thank you so much.
Thank you very much.